Judge Scalia, if you are confirmed, do you expect to overrule the Roe versus Wade?
Excuse me?
Do you expect to overrule the Roe versus Wade Supreme Court decision if you're confirmed?
Senator, I don't think it would be proper for me to answer that question.
I agree with you. I don't think it's proper to ask any question that he's got to act on or may have to act on.
I mean, if I may say why, I'm going to, let's assume that I have people arguing before me to do it or not to do it. I think it's quite a thing to be arguing to somebody whom you know has made a representation in the course of his confirmation hearings, and that is by way of condition to his being confirmed that he will do this or will do that. I think I would be in a very bad position to adjudicate the case without being accused of having a less than impartial view of the matter.
There have been at least some reports that was at least one of the considerations in your nomination. A lot of other clearly strengths which you bring to your own qualifications, but I'm interested in what the precedents you put on the fact of that decision being on the law books. How I'm interested in your own concept in the stare decisis. You believe in it? What is it going to take to overrule existing Supreme Court decision?
As you know, Senator, they are sometimes overruled.
I'm interested in your view.
My view is that they are sometimes overruled, and I think that.
But what weight do you give them?
I will not say that I will never overrule prior Supreme Court precedent. I think that's.
What weight do you give the precedents, Supreme Court? I mean, are they given any weight? Are they given some weight? Are they given a lot of weight? Or does it depend upon your view? Which
doesn't depend on my view. It depends upon the nature of the precedent, the nature of the issue. Let's assume that somebody runs in from Princeton University, and on the basis of the latest historical researches, they have discovered a lost document that shows it was never intended that the Supreme Court should have the authority to declare a statute unconstitutional. I would not necessarily reverse Marbury versus Madison on the basis of something like that. To some extent, government even at the Supreme Court level is a practical enterprise. There are some things that are done, and when they're done and you move on. Now, which of those you think are so woven into the fabric of law that mistakes made are too late to correct, and which aren't, that's a difficult question to answer. It can only be answered in the context of a particular case, and I don't think that I should answer anything in the context of a particular case.
Well, do I understand that your answer with regard to Supreme Court decisions is that some of them are more powerful or more significant than others in terms of their how you would view in overruling them or overturning them?
Yes, I think so, Senator. May I supplement?
And you're not prepared to say on this issue where that decision comes out, as I understand.
That's right, Senator. And maybe I can be a little more forthcoming in response to your first question. As you followed it up, you said that some thought that that's why I was going on to the court or something like that. I assure you, I have no agenda. I am not going onto the court with a list of things that I want to do. My only agenda is to be a good judge. I decide the cases brought before me, and I try to decide them according to the law as I can best figure it out. But it's not a programmatic matter as far as I'm concerned.
Well, that's part of this whole process, giving you an opportunity to speak to those questions, but it also is a part of this process to find out what kind of relevancy you give to previous court decisions and how significant they are in terms of your own legal experience and when they might be overturned or when they might not be. And as I gather from your answer, that's kind of a variable, that some have a stronger standing than others, and that's your view. But in terms of that particular view, you're not prepared to indicate at least in that case, in the Roe versus Wade case, where you come out as to whether you feel that that is a strong precedent or a weak precedent, but evidently you believe that some precedents are weaker and some are stronger in the doctrine of stare decisis.
And nobody arguing that case before me should think that he's arguing to somebody who has his mind made up either way.
Well, then what is the relevancy of the previous decision? Does that have any weight in your mind?
Of course.
Well, can you tell us how much? Or?
That's the question you asked earlier, Senator, and that's
well,
precisely the question I do too.
Depends on the case, doesn't it?
Well, let me go to another kind of question about that you talked about overruling precedents, and that evidently some have a greater weight than others. I think all of us certainly here are familiar with the decision by the court of the Graham-Rudman case. We're also less familiar, but increasingly more familiar, of the decision in the district court. Some have suggested that you might have been the author of the opinion. Whatever that might be, there's a clear indication about questioning the roles of the independent agencies and the allocation of certain executive powers to those independent agencies. This was, I think, probably decided in 1935 as to uphold their constitutionality, and I think maybe you want to comment whether this decision in the district court, how it really fits into that particular holding about the allocations and the authority of the independent agencies.
I don't think it affects it at all, Senator. The three-judge district court decision in Sinar decided the case on the assumption that that the decision in Humphrey's executor permitted the prohibition by Congress of presidential removal except for cause. It was done on that assumption.
Well, there'll I think be an opportunity, I think, at greater length to go into that particular decision and to try and draw out what the courts are really saying about the continued strength of the independent agencies in terms of their constitutional standing.
Senator,
okay.
Before that happens,
right.
Let me tell you a problem I have of discussing it even generally, not in the context of a particular Supreme Court. We have pending, not in the Supreme Court, but before the court that I'm now sitting on, so that it'll be a problem for me whether I'm confirmed by this by the Senate or not. We have pending before us a suit challenging precisely the constitutionality of the restrictions on removal of the members of the Federal Trade Commission.
Right.
So I am very much constrained about
well,
speaking.
Let me we'll back up a little bit because I'm more interested in your approach to these issues. We have seen very strenuous action in the Congress over the period of 30 or 50 years in terms of creating a safe workplace for the American worker. Congress addressed the whole abuses in the child labor laws. We've tried to address the issues in terms of sweatshops, other areas where there's been very significant exploitation of the American worker. One of the newer areas where the Congress has addressed is on the issue of occupational health and safety. This is an area which the Congress has spoken very clearly. Nonetheless, the complexity, very few of us in the Senate, I don't think any now, we did have some, are doctors. These are complex issues. And if it's the decision of the Congress and the Senate that these kinds of decisions are going to be relinquished to an independent agency to attempt to provide for what is a congressional responsibility in terms of the protection of the workplace, and that we are going to give that function to an agency that will draft various rules and regulations. I'm interested in how troubled you are about it, because I have reference to an article that you wrote on note on the benzene case, which and in which Judge Rehnquist had a dissenting comment, in which you also expressed a view, which I would think if it became a majority position, certainly with regards to the occupational health and safety division, would probably mean that that particular agency would be effectively eliminated. I'm interested in your comments, whether I'm
You're
correctly-
asking now not about removal power, but about
Yes.
excessive delegation.
Exactly. And if I could
Sure.
just add to that, one of the points that you raise is the question of vagueness in terms of the drafting of various statutes. I would just interested as a legislator trying to find out where we're going, quite frankly, with you, Mr. Justice, would also, as someone who spent a good deal of time, know that certain language has to be vague in order to permit decisions by, say, medical personnel to be able to draft certain flexibility. Hopefully they're not vague, but they provide a degree of flexibility in order to get the job done. And I'm just wondering what message we ought to have in terms of the future if we're going to run into problems on this.
Well, again, I'm reluctant to talk about what Scalia will say in the future. I can talk about what he said in the past, and I think you have me on the wrong side on the matter of
help me out
of broad delegation. The fact is, in the Sinar case that we were discussing earlier, the principal attack on the legislation was that it was unconstitutional because of the excessiveness of the delegation, and the three-judge district court on which I sat rejected that argument. Did not sustain it. The article that you have there, which is an article from Regulation magazine that I used to be editor of at one period, I don't think, I think you read it incorrectly if you view it as an attack on the constitutionality of broad delegation. To the contrary, I think if I recollect the article you're referring to correctly, it displayed quite the opposite view, the view that it's very difficult for the courts to say how much delegation is too much. It's a very, very difficult question, and I think it expressed the view that in most cases the courts are just going to have to leave that constitutional issue to be resolved by the Congress. Congress has an obligation to follow the Constitution as well.
Well, would I be correct in saying that you would support, then, a broad congressional mandate in these areas?
I would support a broad congressional mandate that is not unconstitutionally overbroad. Yes.
Go around and around.
That's all I can say.
The point that
No, but seriously, I'm not trying to go round and round. I think I am accurate in saying that my writings do not show that I am likely to be more restrictive on that matter than others.
it may I may not assume correctly that in reviewing some of these cases and the articles that you require a degree of specificity in terms of the legislation. And an opinion that you're not going to breathe the life into the words or language of various acts. And there's a whole series of different references I could read. I don't want to take the time. That's what I'm concerned about. Obviously, and I'm interested in whatever response you can give. You know the point I'm driving at. You don't want a unconstitutional delegation, but I'm talking about specificity and in areas which I think the Congress has acted in terms of the protection of the elderly, in terms of the protection of health and safety, and in a whole wide range of areas of protections in health and safety. And I'm just interested in how not only the constitutional question of the allocation of powers, but also the specificity that you require in order to permit these to be upheld.
Senator, I think you have me wrong. I have criticized, and I think I've often said in my writings and in my speeches that Congress should be more specific, that the more specific Congress can be, the more democratic the judgment is, because if Congress isn't specific, the judgment is made by the courts, and the courts are not democratic institutions. So I have criticized what seemed to me as a policy matter, the overgenerality of the statutes. But the reason I've criticized them is precisely because, even though they are overgeneral, they will by and large be upheld and implemented by the courts, and the courts will determine what they mean. I don't think that that is ordinarily the better way to do it, to the extent that Congress has the time, and I know that's a problem. The import of my earlier writings was that Congress ought to try to be more specific, but that does not speak, Senator, to whether, if it chooses not to be more specific, the law will be unconstitutional.
Okay, that's helpful. In an earlier response to the chairman's questions on the free speech, on the Ullman versus Evans, in your dissent, your conservative colleague, Judge Bork, evidently criticized your dissent, noting that you were, I think he mentioned, abdicating your judicial function by your crab view of free speech. How do you respond to Judge Bork?
Oh, I guess I would respond that my dissent was joined by my liberal colleagues, Judge Wald and Judge Edwards. I'll leave it there.
That's enough for Judge Bork. You had an area that this committee is interested in, and that's a question of executive privilege, being able to obtain certain documents. I noticed in your exchange with Senator Muskie, you're talking about this time, they were talking about the Nixon case. And in Senator Muskie concluded in his question, and in your judgment, the right of the Congress to military and diplomatic secrets stand at a lower level than the right of the President to withhold those secrets was a question. You said, no, sir. And then you continued along. I don't mean to denigrate the Congressional. I'll include it all in the record, Mr. Chairman, if I may. Got a statement. I don't mean to denigrate the congressional power. They both, the Congress and the executive, have the right to assert their prerogatives. When it comes to an impasse, the Congress has means at its disposal to have its will prevail. The means are indicated in my testimony. The most effective is the withholding of funds from the executive. The refusal to confirm presidential nominees was also used several times under President Nixon, if I recall, to elicit information which had been previously denied. The Senate simply would not confirm nominees until the information was turned over. I'm wondering if you still
did I say
affirm that wonderful judicious statement and comment that is based upon all these excellent reviews that have been given to you. I imagine you still want to hold to that.
It's true, Senator. How can I withdraw from it?
I don't know whether I should ask you whether you want to expand on that or not, or whether
it's one of the means that the Congress has at its disposal.
In another area, Judge Scalia, this is on the questions of national security and individual rights. We have gone through a rather important period in past history in the early 70s, where we were trying to balance national security interests against the First Amendment. And we've seen recent histories taught us to scrutinize the claims of the executive branch when inhibiting the possibility of inhibiting free speech and association of press and right of dissent under the names of national security. And I just was interested in hearing your own attitude, how you as an individual view the role, whether you view the role as an umpire in our federal system, whether the competing First Amendment and between First Amendment and national security claims, or are you going to give the complete basic and overwhelming presumption to those who make the claim, or are you going to examine in some detail the background for such a claim, or how you'll approach the issue generally?
Well, I will certainly approach it with an awareness of the importance of both of the elements that are in contention there. The First Amendment is of enormous importance, the ability of the people to speak, to learn, and on the other hand, the national security is often national security interest is often of great importance. That's the worst problem about being a judge. It's never something on one side. I mean, you can be criticized for coming out against the First Amendment, and one never hears what's on the other side of that case. There is always some important interest on the other side, or it would not be a case. I can't be, any more specific in response to your question, except to say that I'm seriously interested in both of the principles, both of the concerns that arise in those cases. I'm aware of the importance of the First Amendment, and will give it the full weight that the Constitution accords it.
The reason I bring that up is because when it was alleged and charged for national security reasons, we found the gross abuse of all these individual rights and free assembly during another period, the early period of the 1970s, where we had extensive unauthorized, unconstitutional wiretapping, mass surveillance, and questions of First Amendment rights. I hear my time is up. I thank you. In fact, thank you, Mr. Chairman.
Thank you.